What's good, my people? We are back again for another one on this the one and only Mystelics reaction channel, guys. I know I had to drop videos pretty much every day in March, but of course, due to certain circumstances beyond my control, I was not able to do that. But guys, we got some great news right there. Roosevelt SKERRIT, the Prime Minister of Dominica, has lost to that of the legendary, the youngest one I know of, the youngest lawyer in, of course, this vicinity that you've seen right there. And of course, those who are actually not in this vicinity. But she is doing a thing, and of course, she lost. Roosevelt SKERRIT lost the battle in terms of treating, bribery and treating. And we're going to be reacting to that right there. I realized that this video would not get much hits by itself, so I decided to take it on to share with you guys as well. So this is what we're doing, so other folks can actually know what is taking place in this regard.
Johnson Drigo,
Well, let me bring this
Colin,
back.
Ian Douglas, Johnson Drigo, Colin McIntyre, Rosalind Paul, Ian Pinard, Peter St. Jean, Ivor Stevenson, Kelva Daru, Kenneth Daru, and Antoine Defoe, Enincott St. Vaye, Mervyn John Baptiste. The court's full bench sits this afternoon comprising their honors. Honorable Mr. Justice Saunders, President and the Presiding Judge.
Good afternoon, Council.
Okay, so let's skip that part.
Honorable Mrs. Burgess.
Good afternoon, Council.
Okay. Everybody, good afternoon. Good afternoon to the whole world.
I am Lennox Lawrence, together with Mrs. Heather Felix Evans and Mrs. Jody Luke. For the appellants, we are led in this matter by Senior Counsel, Mr. Anthony ASTAPHANS. My lords and my lady, we wish to apologize for the absence of Mr. Anthony ASTAPHANS, who has a follow-up medical procedure this afternoon.
Of course.
And when I contacted him about an hour ago, he was still at the doctor, so we do apologize for his absence.
Why would he come to a beating like this, huh? Why would he come to a beating like this? Senior Counsel Tony ASTAPHANS. Why would you come to a beating? I mean, come on. I would set my home, my foot break. I wouldn't come nowhere.
Yes.
Anyways.
Enincott involved Mervyn John Baptiste and the late Antoine Defoe.
Yes, thank you very much. Having considered the submissions and deliberated upon this matter, it is the unanimous judgment of the bench
To what?
that the appeal be dismissed.
Of course.
6 members of the court have reviewed it.
By the way, for those of you who don't understand, so first up, the High Court pretty much gave the DLP team the ability and say, okay, we need to put this to the side. Not true? Put the case for treating and bribery in elections aside. They say no, that shouldn't be, and people were happy about that. Anyways, they did another one in the Eastern Caribbean court, and of course, it wasn't unanimous, but 2 out of 1 actually said that yes, they can actually rule in the favor of CARA, Shillingford, and the other folks out there. And they appealed it, DLP appealed it, saying, hey, no, wait, no, man, we need to go back to say, no, this cannot be. Anyways, they appealed it, and of course, it was unanimous that they dismissed this whole thing. So the treating case is back on. For those of you who didn't understand, pretty much the treating case is back on. And that was of 2014, I think it is. Not this election, last election. I think they should also appeal this election as well, because they brought a number of folks in this one. Man, hey. But these things, anyways, we'll talk.
Be dismissed for reasons delivered by Mr. Justice Anderson. Mr. Justice Burgess also considered that the appeal should be dismissed for reasons set out in a separate opinion written by him. I shall now invite Mr. Justice Anderson to read a summary of the judgment of the court and the orders of the court.
Okay.
A reminder that this summary is not intended to be a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. The judgment is the only authoritative source of the court's decision and reasoning, and it is, or will shortly...
Okay.
The issue in this appeal is whether a magistrate has the jurisdiction to hear and determine a charge of treating against a member of the House of Assembly. The issue originated with the filing of criminal complaints in the magistrate's court by the respondents pursuant to sections 56 and 59 of the House of Assembly Elections Act. The three respondents alleged that the appellants, members of the Dominica Labour Party, or DLP, were guilty of the offence of treating by hosting 2 free public concerts shortly before the 2014 general elections.
So it was the 2014 general election. This just pretty much confirmed that. I don't know, hey guys. I don't know if people are blind or something. People want to pretend as if we did not go to these kind of concerts. They want to pretend as if none of these concerts actually took place. That could be as a result of, hey, they're trying to win us over. We are the big boys. Let us treat everybody to concerts and have fun. And yet still, after election, no concerts happen. You know, back you. No. It's only doing World Creole Music Festival and them kind of times. And then kind of times. I don't know why I blurry like this. Why is it like this though? Oh, it's on automatic. Oh. Anyways, so no concerts happen during the time, but during election time, you realize there's a lot of concerts, man. All kind of big names coming down. How much? $250,000 going to whoever, gospel artists and all this. Don't get me wrong, guys. I mean, people have to make their money, but I mean, then people are not supposed to be doing them kind of things like this to try to treat people. And then again, you hear Brother Scary, he like to use God. He like to use God in his thing and then try to make people say, oh, for people to say, oh, it's nice, yeah, Jesus, yes. Look, he mentioning God, he's for us. I remember the very story of the incident concerning the situation involving the axe. The axe thought, well, the trees in the forest thought that the axe was their own because he had a handle that was made of wood. So they kept voting for the axe, even though the axe was the one cutting them down. So people want to use Jesus in their thing. Oh, Jesus and God. And the Bible said he will take and not. Let people continue fooling all you see. Let them continue.
Intending thereby to corruptly influence the electorate to vote for the DLP.
People are like sheep. Sheep. Boy, I tell you, boy.
After the magistrate issued the summonses, the appellants sought judicial review of his decision to assume jurisdiction over the complaints. Stevenson J. held that the magistrate was acting in excess of his jurisdiction since the charge of treating challenged the validity of the appellant's election, and as such, any action had to be brought by election petition in the High Court. This view was premised on Section 40, subsection 1A of the Constitution.
And he's correct. Tony ASTAPHANS them was correct in this regard. But there is something else that they didn't mention in this very thing,
which provides that the High Court has the jurisdiction to hear questions of membership of the House and questions concerning the validity of an election to the House. The summonses were quashed. The respondents appealed. The majority of the Court of Appeal decided in favor of the respondents and reinstated the summonses. The majority stated that Section 59 created a summary process and gave the magistrate the power to summarily try and convict a person for cheating. That power did not intrude upon the accepted exclusive jurisdiction of the High Court in Section 61 of the Elections Act and Section 40, subsection 1A of the Constitution to determine questions of membership of the House. Therefore, the relevant sections did not conflict. The appellants appealed to the Caribbean Court of Justice. The judgment of the court was delivered.
So, in case you didn't understand, what is wrong with this thing, man? So, in case you didn't understand, guys, so when they brought it again, not a unanimous, but 2-1 decision was made as the based on the Eastern Caribbean Court of Justice, stating that there was also another one based on the Constitution. This is why people must know the laws. Know the laws. of your country. Wherever you are around the world, know the laws. There's the provision for you to go the electoral route, and there's also the provision for you to go the criminal way, or in regards to treating and bribery. There are two ways to do it. So I mean, I don't understand why they try to prevent that from happening. That is what I don't understand. And they say throw it all from the High Court in Dominica. That's why, guys, sometimes we cannot even trust our own court system, man. We cannot even trust our own court system because we don't know if they're corrupt or not. We don't know these things. But there's provisions given based on the Constitution of Dominica to say you can either go this way or you can go that way. If this way doesn't work based off the whole system of, maybe corruption, maybe the other way will work around. And of course, the other way around is a bit much lengthier in this regard. So we'll see how that goes as time goes by. But know your laws, my people.
By the Honorable Mr. Justice Anderson, who crystallized the issues before the court as falling under 4 headings: the parallel modes of trial point, the constitutionality point, the weight of jurisprudence point, and the equality before the law point.
Of course. That's a given, man.
In relation to the parallel modes of trial point, the court stated that where a candidate was involved, there were 2 distinct modes of addressing election offenses, evident on a reading of the Elections Act. First,
that's one.
The summary offense procedure, where offenses like treating are tried before a magistrate. Second, the election petition procedure, which was concerned with the undue return or undue election of a member of the House. One of the bases upon which such return or election can be found to be undue is the engagement in certain corrupt practices, inclusive of treating. The imposition of the disqualification from retaining a seat in the House, set out in Section 61 of the Act, did not fall within the summary jurisdiction mode of trial, and therefore was not within the magistrate's power.
Of course.
In relation to the constitutionality point, the court found that the relevant provisions of the Elections Act did not conflict with Section 40, subsection 1 of the Constitution.
That's what Tony was bringing.
First, summary proceedings for treating did not concern the validity of elections. They were concerned to vindicate the criminal law.
Exactly.
Second, on reading Section 35, subsection 4 of the Constitution, it was clear that any person may be convicted of treating, and such conviction impacts, among other things, that person's membership or prospective membership in the House.
Of course. Of course. I mean, that's simple. The simple laws is simple to understand. Apparently, they didn't understand it.
Such a person necessarily included members of the House of Assembly.
Yep. All 21 people.
In relation,
both opposition as well as those who are in power at present. Everyone, no one is above the law. No one is above the Constitution. Even though you heard SKERRIT some time back saying, no law or Constitution going to stop him. Well, we will see how that works out for you, buddy.
The weight of jurisprudence point. The court held that the cases relied on by the appellants were all inapplicable to the present appeal, as they dealt with the quite separate issue of the exclusive jurisdiction of the High Court to determine the validity of an election by way of election petition.
Yep.
The proceedings before the magistrate did not directly concern any question of validity of elections. Those proceedings concerned the criminal prosecution of the summary offense of treating.
Treating. Those involved in treating. So you could use the electoral way to say the validity of the election or the criminal way, guys. And they're nice to break it down for you. Whether you're trying to use treating to win an election. Oh, sweet.
In relation to the equality before the law point, The court agreed with the respondents that the appellate's contention, if correct and put into practice, would create two categories of offenders. That is, ordinary citizens subject to the summary prosecution process and members of the House
So everybody
immune from that process.
No one is immune from the law. Not even if you try to create law that's not there for people to fly drone.
Such an interpretation offended the principles of equality before the law and the rule of law, which were deeply embedded in the Constitution. There was no evidence that it was the intention of the legislature of Dominica to create this bifurcation in the exposure to the criminal law. In a concurring judgment, Burgess CCJ agreed with the decision of the majority that the appeal should fail, but did not agree with all of the majority's reasoning for that decision. Specifically, the Honorable Judge found that the 7 constitutional grounds raised in the appeal were not properly before the court. Sections 103 and 104 of the Constitution were relevant in coming to this conclusion. The former provision is described by Dr. Francis Alexis as the, quote, general constitutional redress, end quote, provision, and the latter, the, quote, general constitutional redress reference, end quote, provision. The Constitution has established a system for constitutional redress and interpretation, which is reinforced by parts 56 and 61 of the Eastern Caribbean Supreme Court Procedure Rules, CPR. As such, no question relating to constitutional redress and interpretation can be raised by way of a segue, as was done in this case, in a claim for judicial review. This threatened to encroach on the majesty of the Constitution. Justice Burgess then moved to the reason why, in his opinion, the appeal should fail. The Honorable Judge noted that the Elections Act created a two-pronged punitive approach aimed at eliminating corrupt electoral practices.
Without it, guys, corruption will go crazy, and everybody, even labor rights themselves, know corrupt practices is happening. But sometimes people believe because you have the money, you have the power to do certain things. Hey, that person, we talk about that in the video today, you know, guys. We spoke about, oh, just because your name on a list and you don't want to say anything, they wouldn't want to give it. But you should get these things if you are truly deserving of these things. If the Prime Minister say you need a house and you know you need a house, you should get it because you truly deserve it in the first place. They stated that these things are for people who actually need it. And of course, according to Syria and all the videos that we tend to put out, where we've seen people who are in need, who are not getting help. Yet still people who are not in need, they are getting houses and all this kind of things there. Building across the board where nobody can pretty much own anything. And they building apartments and everybody Well, let me behave myself.
The imposition of criminal consequences, and second, the unseating of successful candidates.
If treating is proven, they should be unseated.
Active analysis of legislation from various Commonwealth jurisdictions demonstrated that this two-pronged approach is not anomalous. The appellants argued that the words every person in Section 56 of the Elections Act did not encompass successful candidates, and Justice Burgess found that in the absence of express language by Parliament, that argument must fail.
Of course it must fail. So that means certain people will be above the law. And it's for all you, they make it, you know, to prevent corruption during elections. But since you are seated, it's no longer applies to you. I listened to what Tony and Tony was saying in the thing, and I couldn't fathom how he ended up making that assumption on the laws that he was reading. I couldn't fathom it.
For the foregoing reasons, therefore,
I know Tony had to lose that. I know that. I was just waiting for it, and they waiting all my time. They said January they was going to give it, you know, March we know.
The appeal is dismissed and the essential orders of the Court of Appeal are affirmed. And for purposes of clarity, I will read the orders issued by this court. Following are the orders of the court. 1. The appeal is dismissed. 2. The following orders of the Court of Appeal are confirmed.
So, in other words, so if this had to happen again, guys, they wouldn't have to go through that same system because they actually went through it. That's my own personal thoughts on this. And therefore, the process to actually prove that somebody is actually treating bribery and treating will go through much faster. That's just my understanding of it. My professional thing, just my understanding of this thing right there.
Namely, the complaints filed by the respondents and summonses issued by the magistrate's court are reinstated, and B, the chief magistrate shall proceed to assign a magistrate to hear the complaints filed by the respondents.
For those of you who don't know the respondents are CARA them, well, in this case, Antoine Defoe, okay, and his team. And of course, the other one is SKERRIT them that lose that thing there.
3. The stay of proceedings granted by the Court of Appeal in the order dated 4th
And appellants is SKERRIT them. I should have said that.
July 2020 regarding the execution of the judgment and or all proceedings in the magistrate's court is discharged. And 4. The appellants shall pay to the respondents EC $25,000 in costs in furtherance of the pre-trial agreement between the parties.
So they have to pay $25,000. Okay, guys, they have to pay. Remember back in the day, I think they were saying they have to pay $2,000 or something like that. Well, they have to pay $25,000.
Thank you, President.
Yes.
By day, I mean I'm talking about UWP. They say they have to pay $2,000. I think, I'm not sure. I can't remember the figure. But they now Roosevelt them have to pay $25,000. Well, their team have to pay that.
Thank you very much, Justice Anderson. Does counsel have anything to say at this point before we close the proceedings?
No response, Your Honor.
Much obliged.
Yes, okay. Thank you very much. I am Deputy Registrar. Would you please bring the proceedings to an end?
Thank you, Honorable President Saunders. Thank you, Honorable Judges. Thank you, Counsel. Thank you, staff of the...
Anyways, guys, all you get the point already. So, they lose. And therefore, we'll see what comes from this as time goes by, guys. But there's a long road in this thing. And obviously, it's getting closer and closer to the end of this reign for Mr. Prime Minister right there. And the bullying must stop, man. The bullying and all these things. Oh, I can do this and I can do that. Well, we'll see how well this works. I mean, your strongest partner is Tony ASTAPHANS. Your strongest partner is Tony ASTAPHANS. And I mean, even I could have judged that whole system when I hear both of them speaking. Even I. But anyways, guys, what are your thoughts, man? Leave your thoughts on this below. This is just my thoughts on the whole thing, on the whole situation right there. But congratulations to CARA SHILLINGFORD for holding it down, man. And you did your thing, presenting the facts. I like that is what I like, you know, guys. The facts of a situation. Persons want to come and say, especially in my case, persons want to talk about, oh, I shouldn't be doing this, I shouldn't be doing that. Where's the facts of me shouldn't doing? What is the facts of why I shouldn't be doing this? Who tells you I shouldn't be doing? Anyways, let me leave that. At a later date, you will understand the whole situation in this regard. Anyways, guys, if you enjoyed this video, understand this video, or you enjoy what CARA SHILLINGFORD did, if you actually saw that video, give this video a thumbs up on her behalf. And I will see you guys in the next reaction video. Definitely, guys, don't forget to subscribe and turn on that post notifications so you can get all the videos as they come through. I'll see you guys in the next one.